When preparing for this presentation, I decided to look under the hood of the engine of the Dutch tax treaty formation, namely the state. And I asked them the question, do you think currently there exists customary international tax law? And people at the Department for the Tax Treaty Negotiations, they looked at me with dry eyes and said, Dirk, what are you talking about? Go back to your work. So the state of the Netherlands doesn't see any customary international tax law as at this moment. At this moment, and the question we then tried to discuss was, what is the reason that customary international tax law doesn't exist at this moment, and how may that change due to the adoption and ratification of the multilateral instrument, the MLI, that's been signed by the Netherlands, or it will be signed by the Netherlands in a short period of time. So I'm interested, in other words, in the underlying reasons. So why don't we have customary international tax law, and what may change to form it, or what may happen to have it occur? And I think, for my own reasoning, I have to start with the beginning. What is international tax law actually about? Most of you guys, may have a sort of a clue, but it's all about allocating taxing rights between between two jurisdictions, because international tax law consists of bilateral tax treaties, at least in a traditional sense, before the MLI. So what happens in this bilateral tax treaty, in a treaty to avoid double taxation? There's basically two main interests at stake, I'd say. These. On the one hand, a state wants to reduce the tax frontiers of another state, so its businesses can more easily operate in the other state and more easily compete in the other state. So without tax burdens in the other state, competition and doing international business becomes easier. However, if you ask the other state to reduce its tax burdens, its tax frontiers, it will come to you and say, okay, if I reduce my tax frontiers, then you should do the same. So the other competing interest is basically tax money. And the position of each state in this sort of rope pulling exercise depends on the economical relationship, the bilateral economic relationship between states. So position of states can vary from one interstate relationship to the other interstate relationship. And in the end, it's just a reciprocal negotiation, an exchange of, I reduce my tax rate if you reduce yours. So what does it mean? In this perspective, tax law is basically value-free. It's just an economic negotiation where states walk away with the best deal possible. And for that reason, I think customary law, and especially opinion juris, is quite problematic in the area of international tax law. Why do states follow tax treaty law? Not because they believe there's a certain higher value or a sense of obligation, but it's just about economic benefits. I conclude a tax treaty with you. If you reduce your tax burden, I will reduce mine. So this is basically the status quo, or I'd say the situation before the MLI. Customary elements, I'm struggling to sort of recognize them in the current setup, even though there are some scholarly suggestions to the opposite. However, things are changing because the multilateral instrument has been adopted, and what is this thing about? This thing is a result of the so-called base erosion and profit shifting project, the BEPS project. And the big deal of this project is to implement anti-abuse rules in bilateral tax treaties. No more tax avoidance. So the whole point of the BEPS project is to counter harmful tax practices, counter tax avoidance practices. And this introduces, I think, a new element into the international tax game, namely, next to the relevance of economic benefits of concluding tax treaties, there's now some sort of a new thing going on called we don't like big companies to avoid their taxes. We want to restore the fairness to the tax regime. So, does the MLI lead to a changing idea of what international tax law is about? Used to be economic benefits. Are we slowly heading into something where we could say, okay, it's not just only consequentialist or economic benefits that drive the states into concluding tax treaties and applying tax treaties. Maybe we're going to find out some underlying values underpinning international tax law. Let's say the idea of fair shares. And if that's the case, then we might, I think, see a form of customary international law develop in the future. What's also relevant in this regard is that media and the public is driving the concept of fair shares. It's not the businesses themselves, it's the public at large which wants to discuss the concept of fair shares in democratic societies. They're saying, you know, you're not paying up enough, so let's change this. We want to see some movement in this area. So by this increased public attention and in combination with the new idea of fair shares, the question is, maybe then see customary international tax law develop. And the reason I have this assumption is, if you want to have a sense of obligation, then I think you have to find or look for underlying shared assumptions between states, maybe a bit more sociological, constructivist kind of arguments. So why do states follow tax law? Not because it's an economic thing, but because they really believe it's part of a legal obligation to do so. It's just, I've looked at in the internet about the definition of customary international law. It's a sense of obligation. I've heard today something about, let me see, the belief that a rule of law is binding. So this, I think, fits in with the idea of the idea of fair shares. So if that's true, so if my assumption is right, my assumption about the customary international tax law may come into existence when we're going to find some values apart from economic ones, then the consequences would be that the principle-like rules, I think one that Irma will speak about later, like the principal purpose test, which is a general anti-avoidance rule. It's a general idea of the rule is that tax avoidance is not okay. It might be a customary international tax law candidate. And maybe coming a bit back on your presentation, if you want to have norms shared between states, let's say, and if states really believe that a certain norm exists, then it also makes us look at procedural fairness issues. So maybe if we want to have to look where customary international tax law comes into existence, the quality of procedures or the level of right procedural fairness may form an indication of customary international tax law getting into place. So these are my thoughts. And getting a bit more further on this, I think there's two main relevant forms of indication whether procedural fairness exists. First is that you have to have parties coming together every now and then for them to be able to discuss new ideas and critically discuss the ideas of others. Because if you just have a one-time ad hoc affair of concluding a treaty and then you're back home again and you won't see each other again, there won't be a real critical discussion going on. And the other is what I put there with like the cloud thing, the idea that if there is a discussion, it should be held on a transparent and equal and open basis. And if this would come to exist, then that might be an indication that customary international tax law might come to form, or I would say spontaneous, might come into existence in a spontaneous way. That's my, these are my ideas.
Thank you.